It's an important event, and the teams, and I hope this is just the first partnership between Unicristos and the USJAC Law School. Special thanks to Professor Walter for his invaluable help and coordination. Important event and the teams. Okay, so welcome to all, and let's begin. So, Professor Walter.
Eu acho que está dando um eco, Paulo. Você deve estar com o YouTube ligado. Pronto.
It's okay. Sorry. Professor Walter.
Good morning to our teacher and student participation in this event. My name is Walter Moura, and I would like to welcome participation to the international webinar Access to Justice and Human Rights in Europe and Brazil, event co-organized by two Master of Law at Unicristos and the Faculty of Law at USJAC. I will hand the floor over to Professor Juraci. Would you give at your first lecture? Professor Juraci?
Okay, hello to everyone. Good morning to the friends from Brazil. Good afternoon to the friends from Croatia. As my colleague said before, it's a pleasure indeed to have you here and to organize this first event about human rights and justice access. Unicristos is a recent institution here in Brazil. The master program in law is even more recent, but we compromised with the kind of the internationalization. We think that our students need to be in touch with different thinkings and from another centers. We have studied a lot about American law, about German law, about Italian law, but we know very few about the Croatian law. So it's a real pleasure to have you all here. And my lecture will be about separation of power, an institution for protecting democracy. I think that we, Brazil and Croatia, have on this issue much more in common. Our countries have many things in common than the love for the good football games. We can say here in Brazil that the Croatian national team is like the Brazilian in Europe, and that's a huge characteristic for us. But my lecture is on, as I said, on separation of power in some constitutional institution that can almost be a fourth branch of power. These institutions deal with some aspects of the constitutionalism and political issues that the classic operation of the traditional check and balances are unable to deal with. The incapacity occurs when the part-based operation of the legislative and executive branches is compromised. My main point here is that the good function of the three branch of power in the traditional separation of power only works well when it is based on a well-functioning political part system. And we have here in Brazil some issues to deal with this point. So that's the important point. To work well, the three traditional powers need a well-organized party system. A malfunctioning of parties and thus branches of power usually happens to a conflict between immediate political gains and long-term prejudice in a kind of conflict between the current and future generations. It also takes place when a convergent range of political interests by political leaders in parliament and executive branches prevents the regular use of the checks and balance. A common example is the high-level corruption. So, institutions for protecting democracy acts usually take measures before the judiciary branch, forcing it to rule outside its ordinary limits in deciding cases. The intention here, in the action of this kind of institution, the action of the institution for protecting democracy is always to protect democracy and human rights, but in a course of action action that can compromise this very same principle. And I'm going to give you some examples that the intention to protect democracy resulted a threat to democracy. Human rights related to an ecologically balanced environment, which our Constitution expressly sets as a right of the future generation of Brazilians, are good examples of this type of conflicts. The tendency is the politicians in executive, in legislative branches seeking for a short-term popularity, applying economic policies to increase immediate economic improvement, but causing long-term damages to the environment. On such occasions, rights of the future generations collide with the current generation interest for an economic development that could make other human rights effective. One can say that this kind of problem, a conflict between present and future generation, is a common and almost regular conflict in all countries in the world in the present day. One can also say that it's a day-by-day conflict between parts, political parts in parliament. Nonetheless, the party system in Brazil is chaotic. So that's the main reason that here in Brazil, the institution for protecting democracy have gained many importance, especially in the last 20 years. Our political party system is chaotic. We had a 21-year dictatorship in which the number of political parties were artificially reduced to 2. One supporting the government and one playing a consented opposition, a fake opposition. So the collapse of the military regime began in the early 1980s, precisely with the termination of this two-part system. It was an important point of redemocratization here in Brazil to terminate this system of 2 parties. But after it, we have saw year after year here in Brazil a gradual increment of political parties, not necessarily political parties with a true underlying ideology or agenda supporting its actions and programs. Pragmatic scopes in a large spectrum of left-right conflict are, in the end, the real guideline for political parties here in Brazil. We can identify some ideology of the right wing for the left wing, but the day-by-day function of the parties is determined by pragmatic gains. There are today 24 political parties in the current federal parliament, and no one have a slightly possibility to obtain majority in both chambers. Despite this huge number of political parties, one official on executive branch does not need to be affiliated to one of them to keep his office. He or she need to be affiliated to a political party to be elected, but not to remain in office. For instance, our current president, Jair Bolsonaro, left his party in the first year of his administration and have not been affiliated to another one until now. He considered doing it just for the next elections. This chaotic party system here in Brazil leads to what is conventionally called coalition presidentialism. It means that the president must always negotiate the political coalition with the members of the parliament. Due to party fragmentation here in Brazil, there is no possibility to reach a majority directly from election. But this is not the full picture of this complex picture. Brazil is a continental three-level federation. We have federal, we have state, and we have municipal governments. And so the federal coalition must consider these three levels of political interests. In the last 20 years, no party have reached more than 20% of a chamber, 20%. It's impossible to form a cabinet with 20% of both chambers, like we have seen here in Brazil for the last 20 years. Considering this complexity, is very tempting simply to co-opt political support in a kind of quid pro quo deal, which not rarely leads to high-level corruption, another kind of threat to human rights and democracy that the classical Madisonian checks and balances are not efficient to deal with. In Brazil, the car war operation, and in Croatia, the secret club scandal are examples of this risk of high-level corruption that threats democracy and human rights. The importance of the institution for protecting democracy is to act in these cases in which the classical three branches operation are insufficient due to a weak operation of the party system in which it is based on. So we have, on one hand, high-level corruption, on another hand, stagnation resulting from the conflict of generations. These are the proper arena of the institution for protecting democracy, as I said before. Public prosecutors, named here in Brazil, public ministry, human rights commissions, and commissions of inquiry are the most common candidates for a fourth branch of power. But before dealing specifically with the whole of the public ministry here in Brazil, I would like to highlight some characteristics of the separation power as a principle. Separation of power is four different things. Separation of power is a theory. Separation of power is a principle. Is also a set of state institutions and for a specific way of interaction between these institutions. I would like to highlight the separation of power as a principle, a constitutional principle. I can say that the separation of power is a principle of political morality that prescribes the division of state functions between different institutions seeking to guarantee a rule of law. Concretizing in this way political justice according to the precepts of political liberalism and also seeking the protection of human rights. I'm saying this to point out that this principle sets one clear rule. Each power has its proper function prohibited to the other two branches unless the Constitution expressly allows an intervention in this specific function. That is the delicate point on this matter. The intervention of the institution for protecting democracy is important on occasions unanticipated by the Constitution, or if it does, there is no political will to do what is necessary to restrict the abuse of political power. Public ministry, public prosecutors, consider itself allowed to push forward the limits between powers, asking the judiciary to do so. Our Supreme Court have ruled in such cases that the judge, in such cases, acts like an enlightening vanguard. This term is truly used by a justice of our Supreme Court. He considered himself an enlightening vanguard with the duty to push forward the history in direction of the protection of human rights. Is a kind of Platonic philosopher king. That's the rise of the unelected in Brazil. That is the paradox I would like to highlight in these lectures. To fight high-level corruption in Brazil, public prosecutors have controlled the time of process and pushed forward the limits of procedural and substantial criminal law. They have used the press to create a permanent atmosphere of surprising and revolt. They use temporary imprisonment to force plea bargains and confessions. Okay, one can say that is necessary in such cases. The fight against corruption is the scope of any rule of law. And high-level corruption is not a common crime which we can fight with regular tools. We have to use some different tools, but at what cost? Sacrificing defendants' rights seems to be tolerable for some people. After all, they are high-level criminals, but we cannot subscribe it as constitutionalist. Another problem emerges when institutions for protecting democracy seeks to be protagonists in the overall constitutional system. The protagonism of non-elected officials. It's a fundamental characteristic of any democracy that the constitutional protagonism belongs to the members of an elected body in parliament or executive branches, not to the judiciary or a group of bureaucrats. Consequently, the judiciary must have a self-restraint role in push forward its ordinary limits only in exceptional situations of high-level corruption and malfunctioning of the political party game in legislative houses. But this is not an easy case. Here in Brazil, recently, we have some problem that the democracy was saved by this kind of voluntarism from the judiciary. Not only here in Brazil. In US, you have seen another threat to the traditional system of check and balances that is an official populism stimulated by inauthentic manifestations from the people. The invasion of the American capital and the popular demonstrations in Brazil for a coup d'etat, or at least for the demission of the members of Supreme Court, are examples of this another kind of threat. Despite the popular support on both occasions, it was inauthentic ones and cannot be considered democratic legitimation of the act by the crowd or by the president. It is inauthentic precisely because it contradicts the human right that is a substantial part of our democracy. The human right is a substantial point that every democracy must ensure. In Brazil, this attitude from our president based on inauthentic manifestation from the people led to a reaction that had never been seen before by the Supreme Court, and who acted far away from its ordinary boundaries as sketched by the Constitution. The Supreme Court has pushed its constitutional limits to this extreme to protect and ensure the very principle underlying in the Constitution. It was the most serious institutional crisis since democratization here in Brazil. Paradoxically, the head of the Federal Prosecutor's Office, appointed by the President of the Republic, called those inauthentic manifestations as democratic ones. In conclusion, I would like to say that the institutions for protecting democracy emerged on the overall constitutional system around the world, and they have reached some popularity due to a well-known crisis on the traditional branches of power and in the political parties. Brazil is a good case of it. Nonetheless, this very institution can increase constitutional problems instead of solving them. The best solution is to increase the representative instrument and improve the political party system where they are weak or chaotic. Brazil has already done it in 2017 by a constitutional amendment, stating measures against party fragmentation and increasing internal democratic function within the political parties. This is the best way for protecting democracy and human rights. Professor Paula, Professor Walter, this is it. That's my lecture. That's the points I would like to highlight. Thank you very much.
Professor Juraci, no chat perguntaram se o Sérgio Moro seria um exemplo. Não sei se você chegou a ver
não vi.
No chat.
Well, they are asking about the role of Judge Sérgio Moro, the head judge of the car wash operation. When I think about car wash operation, I don't see the problem in the judiciary. Because if you notice, the institution for protecting democracy not include the judiciary. Judiciary is a traditional branch of separation of power. So Sérgio Moro was acting in a kind of inside job in the separation of power. I would like to highlight not the role of the judiciary, but the other institution, specifically the public ministry, that is pointed as a fourth branch. I would like I see a problem in this kind of institution that pretend to be a fourth branch. So the role of Sérgio Moro in car wash operation is quite paradoxal, but is expected in this kind of case of high-level corruption.
Thank you very much for your lecture, Professor Juraci. The next speaker is Professor Mirella Zupan. Would you talk about free circulation of judgments in EU civil justice sharing? Professor Mirella.
Okay, thank you very much. Once again, I'm very happy to take part in this seminar or webinar and actually discuss very broad aspects that may be connected to the notion of human rights and access to justice. I was listening to the professor speaking about public law notion and democracy from that perspective, while my topic is a bit distinct from that one, and I do hope it would somehow fit as a continuation of this discussion. Since I planned to discuss the position of Croatians as European citizens, since we are a part of European Union, there have been many rights attributed to us by the legislation enacted with institutions of the European Union. And one of the big concerns that has been raised over the last few decades in the European Union is the problem of citizens and firms, so businesses, trying to achieve access to justice in some foreign jurisdiction, meaning that they do business in some of the other member states and they need to raise claims in those jurisdictions, or people moving abroad within European Union to find their jobs, or starting a family in some of the other member states, and thereby actually falling, let's say, into a trap of foreign jurisdiction, and trying to achieve access to justice and trying to safeguard some of their rights. So if you allow me, I will share my presentation. Just give me a moment, please. I hope you see the screen I'm sharing. The title I gave to this contribution to the seminar is Free Circulation of Judgments. And it deals basically with the circulation of judgments at European judicial sphere, let's say the territory of member states of the European Union. And the area I deal with are civil matters, which are in most of the jurisdictions in Europe and worldwide very strongly safeguarded by the states as actually resembling their legal history, and they do not want to engage with a lot of unification when the civil law is at stake. That was basically the situation and still is in European Union. However, European Union is an organization which has a very strong common features, and basically it has some common goals that need to be achieved. And if some legal diversity occurs as an impediment or breaches these common priorities of the European Union, then basically the member states would grant power to European Union institutions to enact legislation and to enable those priorities to further develop. Basically, European Union is built on the market freedoms, and thereby European Union is fostering this movement of people, capital, goods, and services. And it has been claimed that European Union actually brings some foreign element and foreign law and foreign jurisdiction to the life of people and firms. And it basically bears, let's say, certain responsibility for ameliorating the risk these people and companies face when they need to safeguard their rights or achieve some satisfaction before the courts of other member states. Hence, this legal insecurity that may occur because substantive law and civil procedure law of the member state is different, has been actually ameliorated by conferral of powers to European Union institutions to enact legislation. This civil justice legislation has been developing since 1999. And basically, we may see that European Union is enacting regulations. Regulations are a very firm unification tool, and they basically leave no space for the member state to retain with their own national law. So regulations are basically deleting, let's say, the national legislation in the specific subject matter that is the focus of the regulation. It is very specific in the European Union that these regulations are developing, let's say, spontaneously, because there's always kind of a possibility that the member states would not be very keen to go for unification in some area. So the unification in, let's say, access to justice and free movement of judgment has been firstly achieved in civil and commercial matters. However, today we have a huge amount of regulations that also deal with different aspects of family life, successions or inheritance, matrimonial property, and some other areas that are basically directly dealing with mutual recognition. There are also some other judgments that have been legislation that is enacted by European Union that pertains to area of civil procedure. I suppose those would be later tackled by Professor Poretti. It is very specific that European Union has this sector-specific approach. It means that one has to be very careful about the delimitation among these regulations that are enacted. And on the other hand, these regulations are in constant interaction with the other legal sources that may be in force in member states. It means that it is a mosaic of rules that has to be applied at a certain point if you want to achieve access to justice in European Union. It means that parties, besides the regulations, need to reach for some unified international conventions. Sometimes they may have the possibility to reach for bilateral rules, and they also have the national legislation that is being still in force at the area where the regulation leaves, let's say, the open space or the possibility for the application. It is very important to clarify that the most important international organization for assuring free movement of judgment is the Hague Conference on Private International Law, and European Union has a very specific coordination mechanism with the Hague Conference, since European Union is one of the participating organizations to the Hague Convention. Thereby, sometimes the rules of the Hague Conventions are enacted directly by the European Union institutions, and member states are not in a position to negotiate those instruments again or alone. What is the cornerstone of the free circulation of judgments and access to justice in civil matters at the European Union is the overriding principle of mutual trust that is codified by the Treaty of Functioning of the European Union. However, this notion of mutual trust is very neatly transposed to this area of mutual recognition of judgments entailing that the regulations that are enacted in European Union basically enable very smooth effectuation of judgments of one member state in the other member state. It means that if a party or a citizen or some firm renders an enforceable judgment in one member state of the European Union, basically that ruling would provide and give effects at the entire territory of the European Union. We should always know that Denmark is excluded of this cooperation. And the usual mechanisms to empower foreign judgments that are basically employed by the national authorities in private international law have been minimized in European Union. It means that there is a certain check of the member state judgment, but it is really reduced to checking some minimum safeguards. Basically, those safeguards are deriving from the fundamental human rights notions, because the foreign judgment would in principle be refused recognition in the other member state only if it would jeopardize some fundamental values that would pertain to public policy of the member state, or if some of the basic or fundamental procedural safeguards were not met, like audiatur et altera pars, or the occasion that the respondent was not notified of a certain claim and he was not able to defend himself. There are some other possibilities to refuse recognition of a judgment of the other member state, basically the res judicata effect rules, and there are some specialties with the with some regulations that I will not go into detail here. Still, if we try to compare the situation of access to justice and the effects one a citizen may have in the area that is regulated by European Union regulations and those that have been left out of its scope, we may see that citizens are afforded with much more safeguards, and basically they can achieve multiple effects with being issued a judgment in one member state. So it very simply gives effect in the other member states, and thereby basically the market freedoms, those first mentioned here, four market freedoms, are effectuated. So the legal insecurity is annulled because citizens have this kind of comfort that if it renders judgment in Germany, that judgment would be easily recognized in Italy or Croatia, and that a citizen will not be in a position that he needs to initiate a new procedure to try to achieve satisfaction or to execute judgment, to enforce a judgment in some other member state. There's this new notion of abolishing exequatur that has been raised with some early regulations of the 2004, but it has been later transposed to other regulations. So basically we have this reversal of traditional methods that are being used. Still, the European Union was not able to introduce this smooth circulation of judgments and provide the citizens with this kind of an environment without ensuring that certain safeguards and checks and balances have been introduced to the procedures of rendering those judgments in civil area. That's why the European Union is basically unifying some other aspects that are very important for civil procedure with cross-border element, and among the core or the main rules that are important for assuring access to justice and free circulation of judgments is the unification of rules on international jurisdiction. However, it is also very important that the law that will be applied is also in many situations unified, either by regulations, or regulations are sometimes directing to some other international conventions that have been acceded by the European Union. Those conventions actually are issued by the or negotiated within the Hague Conference. It is also very important that there are certain common procedural safeguards that are used for coordination of procedures of different member states, and that European Union is actually fostering the cooperation among the authorities that are dealing with protection of civil rights of the citizens or the parties that require protection. It is notable that in this system of checks and balances, the European Union constantly has to achieve a balance with some other notions or fundamental values that have been in force within the member states, as they are by their sovereign rights parties to different human rights or fundamental rights treaties. So in European Union, the most significant piece of legislation that today safeguard the human rights is the Charter of Fundamental Rights that has been enacted in 2009 with Lisbon Treaty. However, that charter is basically a copy of European Convention on Human Rights that are that is rendered within the Council of Europe. And it is very notable that these fundamental human rights protection principles are resembled with the regulations that European Union is enacting, since in most of its regulations nowadays we can find either the reference to some fundamental rights treaties or a copy-paste of a certain rule. For example, when European Union is dealing with the free circulation of judgments in divorce matters or parental responsibility matters, it specifically states that Article 12 of the UN Convention on the Rights of the Child obliges member states to take into account the opinion of the child. There is also a very symptomatic situation that in certain regulations, European Union is specifically targeting the best interest of the child, again deriving out of the Article 3 of the UN Convention on the Rights of the Child. And it is part of the rule which has to be applied by the authority that is facing the claim of the party. I specifically took into account a very European notion of lispendence, since in European Union these regulations that are enacted very often enable launch of a claim in different jurisdictions. So in many of these regulations, we either have an alternative jurisdiction, which means that a claim can be brought before a court of one member state or the other member state, and very often there's the party autonomy. And if parties opt for choice of court agreement, basically they can agree on the jurisdiction that will deal with their matter, but there are still default rules, of course, if the parties decide not to go for the party autonomy. So if we take into account that these grounds for international jurisdiction are alternative, it is very obvious that we may find ourselves in a situation that the same claim is brought before two member states. So we may ask ourselves, why would a party seek for legal protection in the same claim before the authorities of different member states? So are they actually simultaneously initiating claims? Yes, they are. So these matters are basically private matters of the parties, and the parties may try to figure out which jurisdiction is most beneficial for their claim. And we may also say that actually they are looking for the most promising judicial market. So sometimes the two parallel proceedings are basically entering to a very mature forms, and sometimes parallel judgments are even rendered because none of the parties is objecting the fact that the procedure among them in the same cause of action or dependent cause of action has already been raised by the other party before the courts of the other member states. So we may end up with conflicting judgments that basically disturb smooth service of justice. They cause additional costs. They are timely. And if we look at the concept of the European Union, they jeopardize the doctrine of mutual trust that has been developed over the decades or 50 decades of judicial cooperation in civil matters in the European Union. I actually took as an example a very specific provision that is established by the European Union in the regulation that is going to be applied since August next year. That regulation deals with divorce, legal separation, and marriage annulment, and also parental responsibility matters. In these subject matters, the European Union has rendered common rules of jurisdiction, but as I already said, those rules may be misused by the parties because parties may actually want to achieve some better result, and they may resort to different courts. It is very symptomatic that this lis pendens rules is very general in most of the regulations that have been enacted in the European Union, although there are some specifics. So, for example, this newly enacted regulation does not deal with possible parallel procedures in third states. It is maybe interesting for our environment today and the seminar with Brazil that we are left with a question mark. How do authorities of Croatia that have to deal with divorce of a couple that has Croatian or Brazil background, if this couple is in a conflicting situation and they go for a divorce claim in Croatia and in Brazil. Regrettably, this regulation does not deal with this matter, because if we look at the commercial matters in contracts and torts, there is a regulation that has been enacted in 2012, and that regulation has a rule, unified rule on how do we cope with parallel procedures in third countries and the European Union member states. Regrettably, this one deals only with parallel procedures within the member states. That aspect is important because we may see that although European Union claims that there's this very unified approach to access to justice and free circulation of judgments, these lacunas that have been left with the legislation may lead to different results if in different member states, and thereby the parties may be faced with some different outcomes, and they may be in different, of course, situation if they launch a claim in various member states. I do not want to deal very specifically in this seminar today with this notion, but I will just use it as a prototype for a situation when some notion is not defined how do we cope with that notion? So in certain situation, there have been an interpretation provided by the Court of Justice of the European Union, and all of the European Union member states should be obliged with those positions that have been taken by the court in preliminary reference procedures. However, there are some very important issues that have still to be settled, and the national courts of European Union are never have never referred to the Court of Justice to ask for the unified interpretation. So for those aspects, we still just can calculate, and we have different practices throughout the European Union. This provision is also very symptomatic because it pertains to this part of common procedural rules. However, it basically does not deprive the domestic procedural law of its effect. In many occasions, courts of European Union that have to settle claims in cross-border environment, they have to resort to domestic procedural law. I have just pinpointed some of the possible situations when that can appear, and this lex fori approach can again lead to some different positions that the parties may face if their claim is settled by different jurisdictions. It is also very symptomatic that the parties may actually go for a jurisdiction that is very slow. You know, they may go for a jurisdiction that is basically known as a, let's say, bad jurisdiction, or the one that does not deal with the matters very promptly, because in that way the parties actually may reach some results, or they may delay service of justice. It is very symptomatic for some IP cases, but also it appears in conflicting divorces, where the parties want to do, let's say, some harm to the other spouse because they go for a jurisdiction that is either slow or requires first legal separation before the marriage, and they know that their former spouse actually wants to remarry, let's say. Or in IP cases, you know, you actually infringe a patent, but you want to block the courts of the other member states to order you to stop infringing the patent, because in the first years you will be the one that will have the most benefit of some innovation. So you actually rush to the court. You go for the court that you have intentionally chosen, because you know that there's this rule that basically the court that has been first seized has to decide if it actually holds jurisdiction, and in certain positions that court may be in a position actually to delay the service of justice. I have previously mentioned that there's a possibility very often that the parties may choose the court they want to settle their future dispute. However, there's also a possibility that one of the parties decides to disregard that agreement, and that party may launch a claim with some other jurisdiction that would otherwise be able to deal with the case absent the choice of court agreement. And this situation is also called an Italian torpedo. We call them torpedo actions. Why? Because you go for the jurisdiction that was not agreed with your partner. But basically, the basic rule of the lis pendens would mean that that jurisdiction is first seized, and the Court of Justice in its famous Gasser case actually said the first-in-time rule has to apply even in event of such misbehavior of the party. After some of the rulings of the Court of Justice have been rendered, actually, the European Union recognized that some of the rules really deserve exclusions, that some of the rules may be misused by the parties and they may actually jeopardize service of justice at the European Union. And that's very symptomatic again that at that moment the revised legislation actually is enacted, and in revised regulations let's say for this example of breach of choice of court agreement, now we have a reversal of priority. Hence, even if one of the parties misbehaves and goes for the course that has not been agreed with choice of court agreement, it would not be that court that may decide if it wants to proceed with the case. Albeit, the court that has been chosen would have the priority to decide on the lis pendens matter. There has also been a situation with this rule that member states courts do not apply the rules. So the European justice area has all these wonderful goals to achieve. And when we look at the literature, when we look at the recitals of the regulation, when we look at the policy instruments, we may see that the access to justice and free circulation of judgments would be served among the member states, and it would be done on a very high principles of fundamental procedural safeguards. However, sometimes the member states courts simply don't follow the rules. There was a divorce case it is called shortly Liberato case, of spouses of Italian and Romanian origin. And husband launched the claim first in Italy, but in Italy there was actually the legal separation first, and those procedures last because it's the Italian law that is set as such. Wife launched a claim in Romania, and husband objected to this Romanian divorce proceeding, and he said, well, there's already a pending procedure in Italy, and you have to stop this procedure and decline jurisdiction because that's the lis pendens rule in the regulation, and you are a member state of European Union, and you have to assure justice is served based on these European principles. However, these Romanian courts disregarded these objections, and they reached the conclusion of the procedure first, and there was a Romanian divorce judgment issued before the Italian procedure was ended. And this Romanian wife addressed Italian courts, and she said, I want the recognition of this Romanian judgment. And the Italian court says, well, it's not fair that we have to recognize this judgment that has been rendered in breach of our fundamental principles. However, again, the Court of Justice was in a situation to try to find a balance among different principles that are at stake all the time. And these regulations are based on a very strict principle that refusal of recognition of foreign judgment has to stick only to the grounds that have been listed in the regulation. And none of the regulation has lis pendens as one of the grounds of refusal. Breach of the lis pendens is not among the grounds of refusal. So the Court of Justice again said, well, I have to safeguard this principle. And it's rather unfair, of course. So when we look at all these, all the situation or mosaic of rules and principles that have been unified within the European Union to assure access to justice and free movement of judgments, we may in general conclude that European citizens are facing a rather smooth circulation of judgments. There are certificates going along with every regulation. The translation costs are minimized, and basically fundamental procedural safeguards are monitored and they are enforced. However, this unification came with many costs and many doubts, and they have to be settled by basically new legislation that would try to ameliorate those situations. As I have previously mentioned, when the revision of certain regulation is enacted, then the European institutions are trying to find a balance again and try to make some exclusions. The Court of Justice is constantly providing interpretations, so the member states' courts are not allowed to interpret those rules in national constellations. And it is very important in European Union that authorities that safeguard service of justice are cooperating. So in European Union, we basically do not have a diplomatic or classical cooperation among the authorities, but regulations are fostering direct judicial cooperation. Judges are constantly in interference with each other, and other authorities that also deal with these matters may cooperate and communicate with administrative cooperation facilities, which is also enabled in child-related regulations. All of these authorities basically have to be constantly subject to education, which is also provided by the European Union. So I thank you very much for your kind attention, and I'm very open for any discussion on possible issues or matters that have maybe triggered your attention in respect of the matter of civil justice. Thank you very much.
Thank you very much for your talk, Professor Mirela Zupan. The next speaker is Professor Paula Poret. You talk about access to court in the EU way.
Yes, that is correct. Thank you very much. I would first like to greet all of the professors which are here, as well as all our students and all of your students as well. It is so very nice to meet you all, at least via Zoom, and to have this great opportunity to cooperate in such a manner. Although we may seem so far away from each other, obviously these new IT solutions can bring us together in order to discuss these topics which are obviously of our scientific interests for both your university and ours. I would just like to say additionally that just to make a very small reference to the fact that this is not our official uniform, because as I can see, Professor Zupan is wearing almost the same outfit as I am, and we have not been coordinating our outfits for today. Neither is this our official uniform, but it might seem to you in such a way. So let me just quickly start sharing my screen. Is it okay with you? May I start? In order for you to follow my presentation, is it okay? Okay, thank you. Okay, I was very successful from the first try. So I think that Professor Župan really gave an excellent presentation, but also the for me, she made my task so much easier because she introduced you to the basic issues regarding the judicial cooperation in civil and commercial matters and how it influences the our common EU jurisdictions, but I would just like to expand this topic in order to show how the EU legislation really influences also our national civil procedures. I chose this topic in order for you to be able to follow what the recent developments to our national civil procedures are, because I try to find a common ground, because I think that the national civil procedures, not only of member states, but of all states universally, are somehow connected to the fact that they all bring rules which enable access to justice to parties. However, they differ in terms of how they are able to deliver this justice. So so my topic is access to justice the EU way. I would just like to briefly explain the terminology, because and also just to quickly mention that Croatia is a more recent member state of the EU, and this has to be noted in order to understand how our national civil procedure is perhaps seemingly being even more influenced by the EU law and its development than some of the states which have the longer history of pertaining to the European Union. So in terms of the terminology, I would just like to briefly introduce you to the term of Europeanization, which occurs quite often in our scientific papers and our legal literature. However, understanding this term varies between the older member states and the most recent member states, and also how we not only how we understand, but how we interpret this term. What I mean is that although there is still many debates whether there is a European civil procedure, so the common rules of European civil procedure, if they exist or they do not exist still in member states, it is very obvious that by introducing EU law standards to the national system of member states, it is very obvious that there is a very large influence to the national civil procedure. So by the term of the European civil procedure, we cannot talk of a separate legal system existing as such, but there are different, as you have all obviously seen from the presentation of Professor Župan, there are private international law rules, but also the rules of the national civil procedure, which are under the influence of the EU law, which can come under the same term of the European civil procedure law. In Croatia, we are still of the position or that there is no common European civil procedure still. For example, in Germany, the legal literature mentions this term very often, and there are even some authors who write a lot about the topic of European civil procedure law as such. But for Croatian legal system, we can only discuss these private international law rules and, as I mentioned, some national civil procedure rules which are under the influence of EU law and the jurisprudence of the European Court for Human Rights and Court of Justice of the European Union. Why was it so very important to emphasize this point? Namely, in national legal systems of the EU member states, it is still considered that a barrier to a full influence of the EU law actually and the border lies with the national civil procedure, and this is understood as the Revet common doctrine of the procedural autonomy of national member states. So we all have a common idea that there is still a large procedural autonomy of member states, and that the national legislators are free to regulate in this field. However, in the last 15 years, it became obvious that there is a very large influence of the European legislator towards the national legal systems of civil procedure. And this became even more obvious if you look at the different measures which are introduced under both Article 81 of the Treaty of the Functioning of the EU and also Article 114 of the same treaty. In order for the European legislator to legislate in the field or to use its competence under Article 81, the EU legislator is allowed to introduce these measures of judicial cooperation in civil and commercial matters, which Professor Župan already mentioned and explained. However, there is another ground which also allows the competence of the EU legislator, and this is Article 114 of the same treaty, which allows for also measures to be introduced in order to enhance the single market and the freedoms which are guaranteed under this article. Also, there is the widening of the competence of especially the Court of Justice of the European Union within its interpretation of Article 47 of the Charter of the Fundamental Rights of the EU. At first, the Court of Justice of the EU was very hesitant to rely on Article 47 in order to introduce measures which would directly interpret the access to justice standard in the EU member states, but still it became obvious that in more recent jurisprudence of the Court of Justice of the EU, the court is actually expanding its power to also introduce judgments which would deliberate on and interpret the accordance of the national legal system and the Article 47 of the Charter. This is especially important because if you try to understand the influence that the EU law has on the national civil procedure, you can approach it through the historical development, and the most historically oldest influence is actually the influence of the jurisprudence of the both courts, European Court for Human Rights and more recently the Court of Justice of the European Union. So especially in terms of access to justice, it is also very well known to you that the European Court for Human Rights relies on the interpretation of Article 6, paragraph 1 of the European Convention, and Court of Justice of the European Union relies on Article 47. Although the wording of these two articles may seem almost the same, and there are some seamless differences, still they do exist in terms of the scope of one article and the other, meaning that European Court for Human Rights relies on Article 6 within the scope of the European Convention. However, Article 47 widens the scope and not only relies on the efficient legal protection of rights under the Charter, but expands it to include the efficient legal protection of all rights under the EU law, regardless whether they are embedded in the Charter or not. So obviously this is a more expansive interpretation of the access to justice rule. And historically, a more recent effect that the EU has on the national legal systems of the member states and also Croatian legal system is the second pillar. And these are already mentioned regulations on judicial cooperation in civil and commercial matters. Professor Župan explained the development and also the effect of the application of regulations in the field of private international law. And I would just like to quickly add to the table the influence that the interpretation and the application of these regulations in terms of the civil procedure rules, because although also regulations in this field also are introduced by relying on Article 81 of the Treaty of the Functioning of the EU, meaning that they are regulations which should be only applied to cross-border disputes. However, they have a much different role than the Brussels I and Brussels II bis regulations have, because regulations on service of documents and taking of evidence, they are instruments which prescribe the civil procedural rules that should be used in order to for the court to decide in this matter. So they are purely procedural regulations in their nature, and also the manner in which these regulations also influence the national civil procedure, meaning that we learn from the European legislator's manner in which it regulates in the area. Also our judges, because obviously there are no separate EU courts which only decide in cross-border disputes, but these are national courts which decide in both national and cross-border disputes. And as such, our judges, by directly applying these instruments, also are in contact and are being acquainted and have a larger knowledge in applying these different, very sophisticated instruments, which sometimes also brings some aspects of civil procedure which are regulated very differently from the rules of our national civil procedure, and basically that are in some way also different from our national tradition of regulating the procedural rules. And not only these two regulations on service of documents and taking of evidence, but also the Unified European Civil Procedure regulations. And these are regulations of the European Small Claims Procedure, regulation of the European Enforcement Order, and European Order for Payment procedure are very important because they allowed for the judges in this specific kind of cross-border disputes to rely on the rules under this regulation and to apply them to the procedure, meaning that these are instruments which regulate the whole procedure, and as such are very different from the manner in which judges prior to the introduction and application of these regulations were used to deliberate and bring decisions in such cases. And third pillar is actually the most complicated to explain due to the fact that the EU legislator also uses directives, which are primarily instruments with emphasis on harmonization of substantive law in order to regulate in the field of civil procedure. These are instruments not introduced by relying on Article 81, although they also only regulate cross-border disputes, but their introduction is relied on. There are measures which are introduced under Article 114 of the Treaty of the Functioning of the EU, and as such, they are much different from the regulations because they do not directly apply. They have to be implemented in the national legal system, and as such they allow the legislator not only because they are not instruments which are directly applied, but are instruments which need to be implemented. So they allow the national legislator to use these rules not only to regulate for cross-border disputes, but also to use the same rules for regulating the national disputes. As such, they are very influential to our national legal procedure because, for example, the previous two directives on collective redress were implemented in Croatian legal system, and they introduced for the first time the possibility for a group of claimants, meaning not in an individual manner by bringing an individual claim, but to collectively claim redress in consumer disputes. Obviously, the EU legislator is somehow not allowed to regulate in all the fields by relying on Article 114. So the most of these instruments which are introduced under the Article 114 pertain to the field of consumer protection or to field of environmental law or wherever the EU legislator finds it fit to introduce such measure under the common idea of the single market improvement and the free movements. So the interpretation of some of these directives which were introduced to the national and implemented in the national legal system obviously also brought some strange creatures to our national legal systems and traditions, because by interpreting Directive 13 from 1993 of the EU, the Court of Justice of the European Union introduced the ex officio examination of the application of the EU law in every single civil procedure for protection of consumers under the directive. And also in the first stages, the jurisprudence of the Court of Justice showed that the ex officio examination should be done only in the in the individual civil procedure. However, this jurisprudence developed, and now we also have the same requirement for the court to use this ex officio examination even in the enforcement stage of the procedure, which from the position of our national civil procedure does not seem it seems possible, but it is very, for us, it is very uncommon to, deliberate of the subject matter so far within the enforcement stage of the procedure. One other instrument which also pertains to the third pillar is the Directive of Mediation, and also all of the instruments which are enabling out-of-court the consumer dispute resolution, which will be mentioned further on in this presentation, are also included under the same pillar. This was somehow the first category of the influence on the national civil procedure. However, there are two very large categories of influence which can somehow be seen from the development of EU law. The second one are the innovations to the civil procedure, because the EU legislator has the idea of the enhancing access to justice through introduction of many different mechanisms in order to enable the end users or the parties to access justice in a less costly manner, in a more effective manner, for justice to be more consumer friendly, or to deliver justice more quicker. And in order to be able to do it, or to somehow to make the national legislature introduce such measures, there are many policies which rely on the e-justice or the digital justice. There are many mechanisms which should be used in order to enhance cooperations among judges, such as the EU Judicial Network, and many different models of the cooperation, which especially should be used in the cross-border disputes. Also, the use of modern technologies is highly emphasized, not only in these policy documents, but also can be observed within these instruments which are introduced at the EU level, such as these specific unified civil procedure regulations as small claims procedure, or the European order for payment procedure. And also this third category of influence are all the influence of the idea of the alternative dispute resolution, which should allow basically for the same goals to be realized as what were mentioned in the context of the second category. So the out-of-court or amicable or alternative dispute resolution should be used not only to enhance consumer protection, but also to allow both the national and cross-border disputes to be conducted without the need for the parties to be represented by lawyers in a less costly manner. However, one must note that there are also some not only pros but also cons to these ideas, and also there are some downsides, such as the weaker party guarantees and sometimes even questionable quality of the justice which can be delivered through these more simplified procedures, and procedures which lack the basic structure of regular path of delivering justice before court. So I try to explain in some basic terms what these influences to the national civil procedures were historically and more recently. Now I would just like to emphasize at least some issues that we have, or some developments which occurred due to the influence of the EU law on national civil procedure. Should I mind the time? I'm not sure how long my presentation should be. Do I have a few minutes left, or 10 or more? Should I be worried about time? I would just like to, I still have time, okay? Okay, I'll go on, thank you. So
go ahead, Professor, you still have time, much time.
Okay, great, because I wasn't certain, because you know how it is when you just start speaking of a subject, and then you lose a track of time. Thank you very much. So in terms of these changes which have been done to our national procedural law, it is obvious that still we have some issues in regard to the interpretation of the Court of Justice of the EU case law. We had two different rulings by the Court of Justice of the EU in regard to the regime of the European Enforcement Order regulation, and also the regime of the Brussels I regulation. These are the cases Zulfi Karpashic and Pula Parking. And basically what the court said is that the public notaries who were the entities who had jurisdiction to render judgments, which should be then enforced through the regime of the European Enforcement Order or the Brussels I regulation, cannot be considered courts in terms of the application of the regime of these two judgments. And this seems okay, because according to the court, the public notary as an entity does not have all of the qualities, and the judgment which then the public notary renders in these cases cannot be enforced as such under the rules of these regulations. However, we had many problems with the interpretation of these two judgments in the Croatian legal settings, because not many understood that that the Court of Justice of the European Union basically said that these judgments, which are brought by the public notary, cannot be considered as judgments rendered by court in terms of the regimes of the two regulations. Regardless of this, they can still be used in the national and relied on in the national civil procedure, but there were so many misinterpretations in our national legal system, according to which some said that due to these judgments, the public notaries in Croatia are no longer allowed to render such judgments at all. And this is the basic misinterpretation and the lack of knowledge how the system of the Court of Justice of the EU works, and how its case law should be applied at the national level. Also, Croatia was one of the member states who decided that regardless of the fact that the regulations as instruments should be directly applied by judges, there are some aspects that need additional provisions at a national level, and these provisions were actually introduced in our Civil Procedure Act. However, they were not introduced properly, and they were not used properly also. So obviously, we as a more younger and more recent member states still have a lot of adjustments to do in terms of the knowledge on the regime of the regulations. And also there are some adjustments which could be done at the national level, where we could learn from the manner in which these cross-border disputes were regulated for the European, for example, for the European small claims procedure, but still there is a very high opposition in the national legal systems to introduce additional relaxed provisions which would allow for a more quick solutions to the disputes. Also, in terms of the application of the regulation on service of documents, we had also some inconsistency in terms of our national Civil Procedure Act, because still we have a provision which prescribes an obligation of a plaintiff if the plaintiff is a foreigner or he resides in a foreign country, for him to have an agent or a representative to receive communication from the courts in Croatia. Due to the existence of the regulation of service of documents, this provision should be erased, because there is no reason for still prescribing this obligation to the foreign plaintiffs. Still, the provision, regardless of the very recent amendments to the Civil Procedure Act, this provision is still not erased. Also, we expect to have some more amendments to our Civil Procedure Act due to the initiative of the European Legislature to introduce mechanisms of implementing the IT solutions in order to address the efficiency of the service of documents and taking of evidence regulations, in order to be used in a more efficient and effective manner in cross-border disputes. So although we have done some recent amendments to the Civil Procedure Act, as soon as these implementing acts would be available, probably in 2022, we will need some additional changes to our National Civil Procedure Act. Also, one important judgment was rendered by the Court of Justice of the EU, which considered that the obligation of the giving security for costs in cases which the plaintiff is a foreign person, whether legal or natural person, was abolished by the Court of Justice of the EU case law and does not apply in member states. So we had to erase also the provision which allowed for this security of costs for European member state citizens, because the Court of Justice considered that it would be discriminating to introduce the obligation of such costs which would incur in these proceedings for the plaintiff to secure in order to initiate the court proceedings before Croatian or court of another member state. And also in regard to the request for preliminary ruling as a mechanism which is allowed for courts of national member states in order to request the Court of Justice of the European Union to interpret whether the national rules are in accordance with the EU law. I must emphasize that in Croatia we had just a few of these applications, and in terms of now almost 8 years that we are member states, it seems that our judges should, be more competent to request such preliminary ruling, because constantly there are issues of the accordance of the national law and with the EU law, but still they do not feel confident enough to require the Court of Justice of the EU to give a preliminary ruling. If we compare the number of our applications to the number of the applications by Slovenian courts, there are large differences, although the Slovenia is not such a recent member state as is Croatia, but still it feels that it is a time for the Croatian judges also to feel more confident in order to request preliminary rulings in some disputes. And also, as I mentioned, when you look at all of these different influences to the national civil procedures by the influence of the EU law, there is one more also very important aspect, and it's the aspect of introducing some very novel solutions in comparison to our national legal traditions. I already mentioned the collective redress mechanisms and also alternative dispute resolution, especially in the field such as consumer protection, which for Croatian national legal system seem novel and are still underused. And although we have implemented these directives, and now we are already working on the implementation of the new representative action directive for the collective redress, but still when you look at the numbers of how often these mechanisms are actually applied, it is obvious that still there is no confidence of the national legal systems to use these mechanisms more often. This is especially the case with collective redress, because for now we only had one successful collective redress proceedings, which was initiated, I think, in 2009, and only recently was the last judgment of the Constitutional Court rendered in this case, and the case ended. So In regard to the consumer alternative dispute resolutions, the numbers are also not too good, and although there is even Alternative Consumer Dispute Resolution Act, which was enacted in Croatia, I believe in 2017, still it is these consumer alternative dispute resolution mechanisms are not applied often enough. And according to some research, the consumers are still largely unaware of different mechanisms which are allowed under this act to be used. And also, I already mentioned some of these new procedural instruments, such as this ex officio examination of the application of the EU law. Also, there are quite novel solutions. I would just like to mention one of these, which is directly been introduced through the regime of the succession regulation, because succession regulation regulates the rules on jurisdiction applicable law and enforcement of decisions which are rendered in succession matters in cross-border disputes, and it is also applied in Croatia and on all other member states. The said regulation also allows for the public notary or court, whichever body is entitled to initiate and conduct these proceedings, to issue a EU certificate of succession, in which all of the assets would be inscribed, and basically this EU certificate of succession can be used as evidence for the successors of inheritance to be used before national bodies who should enter such propriety rules into the land registry. For Croatia, we priorly had no certificate of succession, which only a decision was applied in order for the entry into the land registry to be made after the succession proceedings. However, member states such as Germany, for example, they go out of their way to somehow act outside of the regime under the argument that they have their own national certificate of succession and they do not need to apply the EU certificate of succession. This is basically a problem not only for Germany and for these proceedings to be conducted in Germany, but is also problematic for Croatian and all other legal systems, because the basic idea of the regulation and its regime is to allow the free and smooth movement of this decision on succession, and in order for the EU certificate of succession to enable for the entry into the land registry of certain parts of the inheritance in each and every member state. So basically, by acting outside the regime of the regulation, there are many, although this can only be one or two examples from some member states, but still they make a lot of problems for the smooth judicial cooperation and also free movement of these decisions in a large number of states. There are some examples which ended before the Court of Justice of the EU in order to interpret whether such actions are allowed by the national member states, bodies and entities in applying these regulations. And also one more obstacle to the smooth movement of the judgment is definitely the fact that the national legal systems in terms of enforcement systems are not harmonized. There are many differences between our national enforcement systems, and due to this there may parties who are in a cross-border dispute, when they get a judgment which needs to be enforced in another member states, can find some obstacles within the national legal system because the enforcement is under the rules of the national procedure. And as I mentioned, these are not harmonized procedures, so there are many impediments to the enforcement in different member states. And finally, as it is obvious that the EU law not only has a great influence towards the national civil procedures and its future development, but also brings some basic ideas of how the justice should be delivered to parties, and there are some recent initiatives in order to find a way how to harmonize all of these different influences and all of these different measures, because it is very obvious that this is a piecemeal legislation. It is actually a very fragmented area, but still, as I have shown here, you can find some basic categories of influence of the EU law, different aspects of the national civil procedure, and they all always come with an idea or a policy behind in order to ensure the shaping of a future national, not only national but also supranational EU procedural law system, which would allow for a more efficient, more smooth delivering of justice, justice which is not so costly, justice which is much quicker for the end users. And in this sense, it seems that the national legal systems are moving away from their tradition, the tradition of being systems in which it is the role of each party to the proceedings, to the plaintiff and the defendant, to somehow advance their legal positions, but towards a more modern way of approaching delivering justice by the cooperation of the parties in finding a balanced solution. Obviously, there are several manners in which this not only should be done, but it is being done. On the one hand, there are some, as you have seen, some solutions for out-of-court dispute resolutions, and on the other hand, there are direct influences towards the traditional civil procedure, and the both are, somehow should ensure for these ideas to be implemented in the national member states. So in order to somehow give contribution to these processes, there was a recent initiative of the early and UNIDROIT rules of European civil procedure. They are shaped as somehow soft law standards by a group of scientists and legal experts in Europe, and from just looking at one small aspect of these rules, it becomes obvious what the basic ideas of how this modern civil procedure in EU should be shaped. Is if you look at the requirement for procedural management, it is obvious that these rules require for the more management of the case, which should be done by the court. The court should introduce a calendar with all of different actions and the prospects to the parties when they should expect for these actions in the procedures to be done. And also there is emphasis on the very active party role of both parties and their dialogue and cooperation in finding the solution to their dispute. This is obviously more a requirement of the out-of-court dispute resolution or amicable dispute resolutions, which is somehow transferred to the regular path of the civil procedure. And also the more active role of the judges highly emphasized, and the judge should again have a more inquisitory role in order to advance the procedure. And the nemo contra se edere debetur rule should be removed because, according to these rules, because not only evidence which advance the position of each party, but also the evidence which go to the contrary of each party should be delivered before court in order for the other party to make use. I've seen some very astonished faces and some looks of disagreement, perhaps even here, because obviously we are moving away from our traditional position of how the national civil procedure should be conducted and which rules should be used, and this all seems to, at least to us from the perspective of the Croatian national legal system, as just moving too far away from some basic standards of the civil procedure. But still, this is the position, at least of this working group, and somehow also these are all conclusions that are to be found in the legal literature, the researches, and everything that was used in order to come up with these rules. And also another principle, which is a very traditional principle of da mihi factum da tibi ius, should be set aside, because the judge should be required to consult also the parties in regard to the law which should be applicable in the case at hand. And also this principle, which I think somehow is already embedded in most of our national civil procedure, of the obligation to initiate some amicable dispute resolution prior to initiating court proceedings, should be introduced. This is only a very small aspect of these rules, which I just took in order to show what influence the EU law standards and all of these ideas of enhancing access to justice have, both from the aspect of the jurisprudence of the two courts and also the legal literature, and also the developments in terms of the introduction of some EU law instruments such as regulations and and directives in our national legal systems, because this is like somehow an end product of all of these deliberations and also all of these processes which are ongoing. So just to make a few quick concluding remarks, it seems that this quest for a new and efficient access to justice may find us to question whether it will bring more legal certainty or uncertainty, because it seems that the national traditions and that the rules that we have been used to rely on do not seem to be applicable, or do not seem to be unchanging, because due to all of these developments, it seems that we are to expect a very different civil procedure structure than the traditional systems are used to. This patchwork of legal regimes and the sectorial approach to finding solutions for enhancing, for example, access to justice for consumers disputes and or some other area can seem to some extent to be an addition to enhancing access to justice. Still we have to be aware that something what may seem applicable for some area or is manageable as sectorial approach can be very problematic if you want to use it and apply it on a larger scale to the whole of the disputes which are decided by application of civil procedure rules. So my final question, which I will leave you with, is are we at the verge of enhancing the weakening of procedural guarantees? Do we opt for just a quicker, more efficient, less costly justice, or do we enhance justice which also have some basic legal qualities? So it obviously is a question which for me for now remains undecided, because with all of these developments it is still to be seen whether they will be accepted as such in the national legal systems of not only member states but perhaps even wider. So now I would just like to thank you all for your attention, and I hope that I delivered a presentation you expected on this topic.
Thank you so much, Professor Paula. I think Professor Valda need to be away, but this aspect that you are present for us about civil procedure is a dream. It's our Brazilian dream either. But here in Brazil, we already have a calendar, a little bit high cooperation between parts. The calendar that is also good for us because it's consequently previously in the judiciary system, and we have consultations with parties before the initiating the proceeding. It's a good point, good aspects that you bring to us, and we are open for questions, any comments about our students, Brazilian students and Croatian students. Anyone? Any question? Any comments? Okay, so I would like to congratulate all your speakers, Professor Paula, Professor Mirella, Professor Juraci. We have had a high audience all the morning. Now we have 60 persons in this Zoom meeting, and we hope that next we can do it presenting and not online. But remember that tomorrow we will start at 9 a.m. in Brazil and 2 p.m. in Croatia, and will be the same link to the Zoom, to enter in the Zoom. I hope this event, I already told this, and I hope this event is just the first partnership between Unicristos and the OJEC Law School, okay? Finally, I would like to thank you, the Croatian and Brazilian students, for their presence and register the invitation to come to Brazil, in Fortaleza especially, whenever possible. So Professor Walter is now here with us for we close the section. Professor Walter, want to say something?
Thank you, Professora Paula, Professora Paula Poretti, Professora Paula Salé, and students at the Brazil and Croatian. Thank you.
If you can open your camera so we can take a photo, if is it possible. Okay, and smile for we register this moment. Wow, thank you so much. So 1, 2, 3, more cameras. Thank you so much. Is it still hot in Croatia?
The summer has ended. It is a very nice autumn. Today, it is a very beautiful day. I think it is 20 Celsius.
Wow, it's good.
Oh.
Here in Fortaleza, we have 30 Celsius. It's always hot. And
Yes.
you are always will be welcome. Now, Professor Walter, we have beautiful beaches here.
Yes, I can imagine. And you should also come visit not only our coast, but also our continental part where
Yes.
our city is situated, and also where you can visit our university and also Faculty of Law. And we would be very honored to have you as our guest and guest lecturers, and also to be able to, you know, spend some time together, and not only cooperate scientifically, but also get to know each other more. So.
Sorry to Professor Paula, and just remember that tomorrow we'll have the Professor Dunja that will talk about human rights protection in Europe. So you must stay here with us tomorrow at 2:00 p.m. in Croatia. And then later we'll have Professor Hugo de Brito Machado, our Unicristos professor, and he'll talk about autonomy and effective principles in European case law, European Court of Justice, and due process of law. By the end, we'll have our professor Denise Andrade, either professor here in Unicristos in our PhD program, and she will talk about women's reproductive rights and the Inter-American System for the Protection of Human Rights leading case. So you must stay with us tomorrow too for our end day. And our event is already a success. I'm very happy with this partnership, and I consider that it's a success. Thank you so much for your all presentations today.
Thank you very much.
Okay.
For having us. So thank you. Bye. Bye.
And the presentation, it will be saved and the YouTube channel, so you can see all the speakers again and again and again, and when the time you want. Okay.
Great.
Show us on YouTube. Bye-bye.
Thank you.
See you
And bye. I
tomorrow.
have a lecture now. I have to go for another lecture now, but yeah,
Okay.
so bye.
Bye-bye. Bye-bye.
Bye, thanks.